Any mention?
May it please your lordship.
Yes, please.
I beg to mention item number 13. I prayed for 2 weeks times.
On the other side.
No objection, lordship.
Yes.
Much obliged, lordship.
Similar prayer for item number 14, your lordship.
Number?
14.
Why? Why take some adjournment?
No objection, lordship. Much obliged, lordship.
May it please lordship. Lordship, I beg to mention item number 22.
Number?
22.
No objection, your lordship.
I pray
No
for 2 weeks
objection,
time,
no
lordship.
objection, no objection. I'm looking for a day when the other councils say we have objections and 2 hearings. Otherwise, we'll have only a hearing day. We might change the roster that on 1 day and 2 days in a week, only hearing matters will do, like other courts do. Then you won't have excuse. Otherwise, it's reflect very badly in the bar. Yes.
Kindly oblige.
Yes.
Please, your lordship, I beg to mention item number 17. Can you have this matter up to 2 weeks, your lordship?
No objection.
I have no objection.
Yes.
Oblige, your lordship.
Lordship, I beg to mention item number 16. 2 more weeks may be granted.
Objection is lordship.
For joinder?
Lordship, pleading is done. Pleading are done, your
Take it
lordship.
up.
Lordship, the only thing is that here the complaint is only for material component. No one is suffering. Since Lordship, my family member was hospitalized for 2 weeks, I cannot prepare it well. So I just
Prepare what well?
Your Honor, I don't have
Your
time.
personal problem.
Yes, Your Honor.
Okay then. You just
1 week,
ask for
your
1
lordship.
week.
2 weeks, Lordship.
Okay,
Because
2
I have to go back to Guwahati only.
Okay.
Obliged.
Yes.
Please, your lordship. Your lordship, I beg to mention item number 20.
Number?
20, your lordship.
20, your lordship.
Why?
Mr. Provident is our station, your lordship.
This Horsotun, Posna, Kharjarin, Yobor, Esmilim, all of them not competing to argue this matter.
Your lordship, I'm on behalf of respondent 6.
Or respondent. Oh, sorry. No objection?
No objection, your lordship.
Yes.
Deeply obliged.
Yes.
Item number 21.
Yes. Who's
No
other?
objection.
Lordship, provision adjournment for 3 weeks, Lordship.
Take 6 weeks. Better?
3 weeks.
4 weeks, yes. 4 weeks, yes. After 4 weeks, yes.
Lordship, I beg to mention item number 18 and 19. They are connected matters.
Samir Chandrakar.
No objection, your
No
lordship.
objection. 2 weeks, yes.
Highly obliged.
Supplementary list item number 1.
Yes.
May I please, your lordship? Lordship, this is an application for transfer of possession matter of Markowat.
Succession matter?
Yes, of Markowat, lordship.
Succession matter?
No, transfer, for the transfer, lordship, an application for transfer of possession matter, your lordship.
A sessions case.
Yes, your lordship.
When those matters listed?
10 September. 10 September, your lordship.
When they listed? 10 September?
10 September, yes, your lordship.
Is your name? Sorry.
SD Sangma, your lordship.
Yes, heard MS SD Sangma. Issue notice. MS. What about respondent?
Am I audible, Kumar?
Yes, yes.
Can you see the order part by session there at page 17 of the class?
17.
Yes, sorry, 20. Page 20 where
Yes.
the order is passed at page
Yes.
20. page 20.
Yes.
Now, if you also notice the difference as per this, submitted that victim, complainant and accused persons in this case are local tribes living in so-and-so village, which is within the jurisdiction of Karachi and Autonomous District Council, as alleged incident happened in this village within jurisdiction of District Council, and for trial of cases between parties who are belonging to scheduled tribes in such areas, incident court is District Council Court, which has been empowered under paragraph 4 of the 6th schedule of the Constitution. Paragraph 4 is also at sea. It is only in those cases where sentence is less than 5 years, and they rely on the state of Meghalaya versus Melvin.
Where's Mr. Pandit?
Yes.
He's on the way, Your Lordship. He couldn't reach on time, Your Lordship.
Yes.
So, Melvin judgments also will not apply because CRPC notification, Your Lordship, and DNSS notification, Your Lordship, has seen was not there when the Melvin judgment was pronounced, my lord. And in Melvin judgment also it is stated, my lord. And their whole case is that the trial is covered by paragraph 4. It's a case of kidnapping. It's a case of, if you also will see the charge sheet at page 17. At page 17, you also will find. The prosecution story of the case is the complainant, Sri Bala, son of so and so, to the effect on 5th December 23, with intent to hurt and kill him as they made multiple threats against him for past 2 years, seeing the person in the road brought quickly. Complainant fled away from his residence as they could find, became frustrated because the father and his resident tied him and took him to the residence of so and so. And tied complainant so and so and threatened with cocaine and started assaulting with his stick and hit him on his head and face, which caused grievous hurt to him and lost consciousness after incident. So kidnapping, the grievous hurt, these are offences which are punishable with sentence of more than 5 years. So it is not covered under paragraph 4, If you also will see the previous page at page 50. 15 and trial has been going on, and
When did this has happened in?
the charge sheet may not be
23.
And it is at least 23 million. Now, and the prayer is also that paragraph 4 will apply, 9/2023. So this is not one of those cases where the case is that.
Okay, we'll issue notice. Let you give the paragraph respondents here also. Yes, but MSSD Salma.
Yes, Your Lordship.
Issue notice. Respondent number 1 is represented by Advocate General and MS Arangwa. No further notice. Notice issue to respondent number 2 within 3 days. Yes, less after 3 weeks.
Obliged, Your Lordship. Much obliged, Your Lordship. Item number 2.
May I please, Your Lordship. Lordship, this matter pertains to non-declaration of result, Lordship. Non-declaration of the result. The petitioner here are they belong to other backward classes, Your Lordship. And on 29/1/2025, the government has invited application for the candidate from for MTET who are permanent residents of Meghalaya, and the pass percentage for OBC category is 68 out of 150, Lordship. And the petitioner has applied online, and the result for MTET examination was declared on 16/6/25 for all categories, Lordship, except for OBC category. And when the result was not declared, Lordship, the petitioner has submitted online complaint. However, there was no response in that regard. Thereby, Lordship, the petitioner was compelled to file an RTI application, wherein in the RTI application, it clearly shows that the petitioner has obtained petitioner number 1 84, petitioner number 2 71, and petitioner number 3 77 marks, Lordship, which indicates that they have duly passed the MTET examination. But however, Lordship, till date the result was not declared for them. So, Lordship, at this stage,
where's your query?
Lordship,
Where's the RTI query and reply?
RTI is at page
You asked for your marks.
page 36, Lordship, an extra 5.
Only for your marks.
Page
You
36.
asked only for your marks.
Lordship?
You asked only for your marks only.
Lordship.
Yes, Mr. Shuaib, but there's no OBC category in Meghalaya.
Lordship, it's very spray, your lordship, because what happened, it appears, your lordship, a certain overseas certificate have been annexed, your lordship, in spite of the fact that state of Meghalaya does not have a notified list.
Where is the certificate?
Lordship will kindly come to page,
Is this page 26?
lordship, it's, lordship, yes, 26, 27, lordship. You don't have a notified.
What is the case this one? Other bypass under the loop.
This is 2009.
After Governor Assam notification.
This is one is 2009, one is 2004, your lordship.
You take instruction.
I'll have instruction, your lordship, in the matter.
You third MSD motor. Then compulsory issue notice. The issue LLEG will soon run acceptance on behalf of all the respondents. No further notice called for. List after 2 weeks for instructions affidavit. Yes.
Apply, your lordship.
Item number 3.
May I please, Lordship?
May it please your lordship. Lordship, this matter, your lordship, pertains to the termination of my mining lease and environmental clearance, which have been validly granted to me, your lordship.
Environmental clearance.
Yes, your lordship. Brief facts of the case, your lordship, is that I am a businessman engaged in the business of boulder stone mining in Umduba village in Ribhoi district. The environmental clearance, your lordship, was granted to me on the 16th of July 2018 and the mining lease on the 30th of March 2019. Thereafter, your lordship, an application was filed by one Shri Jutul Deka before the Honorable National Green Tribunal, your lordship, with alleging, your lordship, that there are illegal stoned mining activities in Ribhoi district and that the authorities had failed to adapt the cluster approach before granting the environmental clearance in cases of the mines located close to each other. He also prayed, your lordship, that this illegal mining in Ribhoi district shall be prohibited and that the lease granted for the same shall be cancelled. Now, your lordship, in pursuance to this application filed by Shri Jutul Deka, the respondent number 2, your lordship, had issued a letter to me on the 1st of November 2019.
Which
Your lordship
19?
will, yes, your lordship. Your lordship will have that at page number 76.
Filed when was the application filed?
This may not have, the Lordship will find a page. 86 million. 86 is of 2019.
Okay. Yes, continue.
Your lordship's come to page number 76. Your lordship, this is the order that was issued to me by the respondent number 2.
76.
76, your lordship, and extra 15. Now, your lordship, I am the owner of 2 mining lease, one measuring 4.05 hectares and another 4.45 hectares, which is the subject matter of this writ petition. Now,
Which one
respondent,
matter? Second one.
the second, 4.45 hectares, your lordship. Now, write this letter, your lordship. Respondent number 2 had stated that with regard to my first mining lease of 4.05 hectares, the same was deemed valid because at the time when the mining lease was issued to me, there were no mining lease located next to each other within 500 meters. However, with regard to this mining lease of 4.45 hectares, the same was subjected to cluster norms as the distance between these 2 mines were located next to each other within 500 meters. As such, your lordship, respondent number 2 cancelled my mining lease.
That's the only reason for cancellation.
Yes, your lordship.
Not on any pollution
No, your lordship.
considerations.
No, your lordship.
Where's the cancellation order?
It's at page number 76, your lordship.
This is a cancellation.
This is the, yes, your lordship. After this, your lordship, I had,
second.
lordship.
Okay. So what is the, where's this prescription that it should not be within 500 meters of each other? That's not the case. This is NGT prescription.
No, your lordship, this is the prescription.
Who has prescribed this to say this condition?
Ministry of Environment, Ministry of
Where's that?
MOE.
Where's that
Your
letter?
lordship, that letter was not being provided to me, your lordship.
No, but then before you've come before this court, you should have gotten the materials. If the reason for them not to allow the second mining lease is that it's because 100 meters, where is that in your custody? Do you have a copy of that Mr. Archival
Your Lordship, I
General?
had written various representations also, Your Lordship.
This issue, may I submit, Milord, this issue was adjudicated before NGT, Milord, this cluster mining by Jitul Dekha. So Lordship will kindly see page 98. The judgment of the NGT starts from page 86, page 86. And it was adjudicated, Milord, and pursuant to that, Milord, if you also will see 20, page 24, where detailed so far is there, Milord.
24.
Detailed so far is page 111 at annex 20, Milord. The Lordship is so-called notice for violation of cluster norms notified in Environment Impact Assessment Notification 2006 as amended by the MOE of CC notification dated so-and-so on Meghalaya Minor Mineral Concession Rules. Whereas National so-and-so by final judgment has directed the state government to examine the minor.
So what grounds are you challenges? If there's a prescription of the MOEF with cluster mining, on what grounds are you challenging?
On grounds, Your Lordship, that no opportunity was given to me of being heard, Your Lordship. Moreover, Your Lordship, I had, on the termination of the respondents of my mining lease and environmental clearance, I had filed an appeal before the Honourable Supreme Court and also a writ petition, Your Lordship. The Honourable Supreme Court, Your Lordship, at page number 147, Your Lordship.
What does it say? You filed with regard to the other mining lease?
Yes, with regard to the
first
4 point, yes, Your Lordship, the first one.
Yes.
Page number 147, Your Lordship. The Honourable Supreme Court, Your Lordship, had dismissed of my writ petition, Your Lordship, stating that it would be appropriate for me, Your Lordship, to invoke the jurisdiction of the High Court, Your Lordship.
When was this passed?
This was passed, Your Lordship, on the 10th of October, 2023.
So this is the petition after this, that's why you come today?
Yes, Your Lordship.
After 23?
Lordship, even after this, Your Lordship, I had, on the basis of this judgment, Your Lordship, I had withdrew also my civil appeal which I had filed, Your Lordship. And after this, Your Lordship, I had addressed various representations to the respondents, Your Lordship, addressing my grievances, Your Lordship.
We will file counter affidavit, Milord, in this matter.
No, because you see, one thing, you are MS no long, right?
I am linked, Your Lordship.
Lindo, sorry. You are challenging order which is dated 1st of November 2019, 6 years old, right?
Lordship,
Then anyway, we will issue notice.
Milord, kindly issue notice in these two matters. One more.
Yeah, two matters.
respond, item number 4 is also connected. Item number 4 is regard to my second mining lease of 4.05 hectares, Your Lordship.
Both have been terminated.
Yes, Your Lordship, both have been terminated.
But just now you submitted that the first one has been passed and only because of proximity of the first lease to second lease, your second lease has been cancelled.
No, Your Lordship, first the 4.45 hectares was terminated on the ground that this was adjacent to the 4.05 hectares. Now after this has been terminated, then they terminated my 4.05 hectares, stating that this is terminated adjacent to this, Your Lordship.
One solution, Milord. Kindly issue notice. Milord, Jitul Dekha has now filed one interlocutory application in the Honourable Supreme Court regarding illegal stone mining in Rivoi district. Honourable Supreme Court has directed Central Empowered Committee to inspect and give the report. Central Empowered Committee inspected the entire site and has given the report, and now matter in the Honourable Supreme Court is listed on 12th September. But we not kindly give us sufficiently some more time so that if some adjudication takes place on 12th September, we will file reply after that, because this is all illegal.
12th September. But they're not engaging any mining, Mr. Archival General. The only thing is that they've come against the cancellation. You've not started any operations, correct?
No, Your Lordship.
Yes, sir.
Then?
Yes, sir. Because some overlapping is there. That was my some overlapping.
MS, I am Lindo and counsel with the petitioner. You should notice. You are appearing here also.
Lordship, yes. Maintainability also may be kept open, Your Lordship, in these two writ petition, Your Lordship.
You should notice. Archival General and Additional Archival General also present on behalf of the respondents number 1 and 2. Notice issue
1, 2 and 3, Your Lordship.
No, Member Secretary State Environment Impact Assessment.
Lordship, yes, he is a principal chief conservator of forest, Your Lordship.
3, no further notice the respondents. Notice to issue to respond number 4 within 3 days. Stop. As the matter pertains to a lease that has been cancelled as far back 2019.
And also my environmental clearance, Your Lordship. Also my environmental.
September and 1.
Just after 3 weeks, this was talking to affidavit.
Apply, Your Lord.
Same order in the other case.
Lordship, yes.
Item number 5.
Lordship, I'm praying if the matter can come up at the end of the board, Lordship.
After some time.
Six.
Yes, number 5 to number 7.
Daily list. Item number 1.
Lordship, we were in this case, on composite order, Lordship. The judgment which I placed before this court on composite order, Lordship, it has, my learned senior has informed that it has been stayed in the Honorable High Court. Lordship, I'll place the Honorable High Court's order, Lordship.
Give a copy to you. You will copy to Mr. Sen.
Lordship, I'll give him. Lordship, it's a simple order, Lordship. Now, Lordship, here what happened, Lordship, Delhi High Court Bar Association has filed this case on Gaurav Enterprise, stating about the Gaurav Enterprise. What was the prayer, Lordship, they made? Lordship, the limited prayer for the petitioner in this petition is extracted as under: to issue writ of certiorari and or mandamus or any other appropriate writ, order or direction to quash set aside annual modified order dated this only to the extent relating to order under section 7Q, only to the extent, Lordship, and remand the matter with further direction to CJIT Labour Court, Delhi, to adjudicate, decide the order under section 7Q dated this, along with the order 14B as composite order, Lordship, in the pending statutory appeal and or any other order or direction which the Honorable Court may deem fit and proper in the interest of justice. So, the prayer of the Delhi High Court Bar Association is also in the single bench itself, Lordship, is also to remand back the matter to CJIT. Lordship, now I am placing also, I'll give.
So now what does this say?
It is regarding the composite order, Lordship.
It's not a final order.
It's not a final order, Lordship. No, I'm just my entire base of the main case which I have placed regarding Gaurav Enterprise is that it is a composite order. 14B and 7Q, though it is passed in a separate sheet, but it is a composite order. So they have come before the Honorable High Court also stating that it is a composite order and it has to be remanded back to the CJIT for the adjudication, proper adjudication of the case, and it has to come through appeal through CJIT, not direct as a writ. Now, Lordship, for the simultaneously, Lordship, this Rajiv Gandhi Cancer Institute Rajiv Gandhi Cancer Institute, these orders, Lordship, para 24, Lordship, page number 8.
Yes.
Thus, when the enquiry is common, show cause notice is common, the reply is common, and even the proceedings are common, the mere passing of two separate orders on the same date would not render the proceeding under 7Q and 14B independent of each other. Now, subsequently, para 25, Lordship, in the learned division bench of this court, in Net4 India Limited, Union of India, decided on this, clearly holds that when the interest under section 7Q is included in an order passed under 14B, the same could be appealed under 7I, Lordship. Further, Lordship, in para 28, Lordship, Considering the fact that the initial imposition of interest under 7Q was contained in the order passed under 7A and thereafter a common order which was passed on 9 February holding the establishment liable even under 14B, the mere fact that the computation was made in two separate orders would not render the order independent, Lordship. So if the order is passed on the same day, Lordship, mere on the ground that the orders are on two separate order sheet, Lordship, then it not amount that they are independent of each other.
Yes. So, Mr. Sen, we will remand. We will. You cannot.
No, I'm not saying this is
Why?
I need to. My Lord, what is this judgment? I could not understand. My learned friends have gone through, but
What your learned friend is saying is this, very simply, that 7Q 14B, although they were passed in separate sheets, it amounts to composite order which is available under 7I.
I got it. Because last occasion, my submission is this, that Gaurav Enterprise, whatever has been passed, that has been stayed by the division bench. Now my learned friend is referring to some judgment, my Lord, I'm unable to get it. If she gives me a copy, my Lord, I'll just come back on Monday. This on Monday I'll come back.
We give them a copy. That is, we can.
Unable to get it, my Lord. I'll just come back on Monday.
Today, MS P. Bharatsaji has produced a judgment of Delhi High Court on the point of composite order under 7Q and 14B of the Provident Funds Act. Stop. Mr. S.N. praised him allowed 2 days' time just to approve the same. This next week.
Well, there is an interim order till then.
But I think because that's a general trend now. I think that if you separate these two, it leads to incongruous kind of a situation.
Archival engineering, my Lord. Archival engineering, if you lost, you will rely on it. Archival engineering, they said, is a very serious thing. The appeal is the creation of a statute.
Yes.
If it is a creation of statute, my Lord, court cannot substitute this. My Lord, that is it. I'll try.
Lordship, the Archival engineer, this case is relied on Archival engineer only.
That's how we interpret.
I'll try, my Lord. I'll try to distinguish.
Item number 2.
Yes.
MSCRC has filed a detailed reply.
Lordship, with respect to item number 2, Lordship, as instructed by the client, Lordship, there are some outside court settlement talks going on between both the parties. And so, Lordship was kindly advance this matter for 4 weeks.
Adjourn or withdraw?
Adjourn, Lordship, for now. We'll take 4 weeks to decide.
Yes. You are? Mr. What's his name?
SJ, sir. SJ, sir, Lordship, for petition.
Mr. Ajay Saikia, the counsel petitioner submits that as there is a possibility of an out-of-court settlement, he prays the matter adjourned for 4 weeks. Yes, very allowed.
There is an out-of-court settlement with the commission.
It can't be to the commission, of course. Will be reported to the commission. Yes.
Even today also we're not able to. Actually, the affidavit is ready. We've given it to the party concerned R6. So they've checked the affidavit, but there's certain things that they are not satisfied with.
You send the affidavit to the Darbar?
No, to the village, Darwashnam. So they have checked. They said
what
it's
is that? Once it comes to a lawyer, that means
I understand.
It's up to your instructions. How instructive
we've already prepared for certain things that they have not understood.
First time I've heard that you prepare an affidavit and you send the affidavit to Darbar for discussion.
No, they already 90% is fine, but certain things they're not satisfied. Just give us 2 more weeks.
Accept that, Mr. Markwan.
Give us 2 more weeks. We'll file it after 2 weeks.
Good village, your good village.
Good village, good village. R6.
What to do?
Lordship.
Stop the affidavit.
Last opportunity, Your Lordship.
Yes?
Last opportunity, Your Lordship.
Affidavit as it is ready. Just start things that we need to settle.
Yes.
2 weeks, sir.
Mr. Markwan today again has renewed his prayer for affidavit due to.
Lordship, the interim order may continue.
Due to circumstances beyond his control. Sub is expected next date. Therefore, should be on board. Just after 2 weeks, yes.
Lordship.
Interim orders, if any, shall continue till next date.
Thank you, Lordship.
Item number 4.
for affidavit, I'm praying for some more time.
For affidavit, Your Lordship. Your Lordship, I would just like, I feel an obligation to inform this court that we had filed a Section 9 application in the lower courts, and the Honorable Court has granted us status quo on the cancellation of the contract.
Is that correct?
We have issued notice.
Yes, as prayed for the 2 weeks time allowed to the respondents. This is the second time it's come only.
Yes, Your Lordship.
What about the name? You said
Section 9.
Section 9.
No. What Section 9 now status quo? That what bearing will have here?
On cancellation.
Just only for information of this Honorable Court.
Cancellation is kept in the question of one to arbitrate will not arise now.
You take instructions.
Your Lordship.
You take instructions.
All right, Your Lordship.
You put the order of the commercial court. Yes, yes, after 2 weeks, to enable counsel to obtain necessary instructions. So both of you.
Have Your Lordship.
But if you file the affidavit, you indicate the names of arbitrators there only. Be simpler. If you're filing affidavit.
No, because it seems that they've obtained ex parte order. We have not heard of it. We'll take steps for that also.
Highly obliged, Your Lordship.
May I please, Your Lordship. Your Lordship, the order has been complied with, Your Lordship.
Very good. Are you aware about that?
No, Lordship.
Not
A
aware.
copy has been sent, Your Lordship, to the petitioner. Maybe they've not received.
Not yet received.
Yes. MS Ailangwa today submits that the order stated to be violated has since been complied with. A communication dated 6 August 2025 has been produced to substantiate this fact. Accordingly, the contempt applicant stands closed and disposed of.
Much obliged, Your Lordship.
Item number 6.
May I please, Your Lordship? In this matter, we took steps, Lordship. Some more time.
Steps.
Yes, Lordship. Some more time.
Return and serve. To number.
Yes.
Number one. Number one whom? In your course title.
Srimati Agatha, Chief Engineer, Lordship.
Number one is.
Chief Engineer.
Who's Agatha Doreen Bla?
Chief Engineer of Water Resources, Lordship.
I think you verified the address. It's come back as no such person. There's no such person or no such person address.
Okay, Lordship.
Stop the notice to respondent one is returned unserved as, and it is noted in the postal receipt that no such person, this address exists. Stop. MS GT Sangma, right?
GCH Marak,
Oh, sorry. To verify the address and to take fresh steps. Just after 2 weeks. Yes.
I will bless, Lordship.
You verify, otherwise wrong. Maybe this person doesn't exist also.
Okay, Lordship.
Item number 7.
Please, Your Lordship. Order is yet to be complied. This pertains to pay parity of owners in some records.
This is the first time they are appearing.
Lordship.
Yes, MS Merchang advised Dr. Mozika entered appearance on behalf of
All the respondents.
all the respondents. Stop. Praise for around 2 weeks' time to file affidavit. Yes.
Item number 8.
Your Lordship, I'll be filing my rejoinder in the course of the day.
Yes. This is the last one we asked. That's it. Rejoinder we find the course of the day. It's a matter of hearing after 2 weeks, Lordship. 2 weeks, yes.
Obliged, Your Lordship.
Obliged, Lordship.
9.
Please, Your Lordship. Your Lordship, this
Yes.
This matter, the private respondent number 4 and 5 have filed their miscase vacating the interim order dated.
For vacating?
Vacating the order.
Has it been taken up?
No, Your Lordship, was supposed to file a show cause. It requires me to file my show cause.
When was it filed? In this case?
Sometime in July.
In July, now not taken up. That means by 2263 it will be promptly vacated.
Your Lordship, no, well, I require to file my show cause reply. I'm praying for 2 weeks time at least. You know. Simultaneously, I will be filing my rejoinder as well.
Where's Mr. Where's Mr. Day? Who filed a miscase?
Me.
Or you filed a miscase?
Yes, Lordship. Somewhat I'm Lordship to they're supposed to file the objection, Lordship.
I require 2 weeks time, Your Lordship, to file my show cause.
Praying on their behalf?
No, Lordship.
Okay, we'll give you 1 week's further time.
Okay, 2 weeks, Your Lordship.
Okay, 2 weeks further time was played allowed for objections to the miscase number
150 of 2020, 160 of
the miscase
2025.
160 and main case list on together on same day. Yes.
Deeply obliged, Your Lordship.
10.
As per your Lordship's last order, Lordship, we have renewed the bank guarantee, Lordship, till 26th of September 2025, and the same will bring it on record by filing an additional petition.
Yes. Yes, MSR, West. Yes.
The talks of settlement were going on in this matter, but as per the instructions, it cannot be materialized.
Okay, anyway, Mr. Saikia submits that the bank guarantees has since been renewed. He prays allowed to bring the same record with affidavit. Prays allowed. Stop list after 2 weeks. Interim order of any shall continue to next date. Yes.
11.
My Lord, item 11 pertains to non-communication of ACR, due to which, my Lord, the promotion in 2024 was not done.
I'm praying for some time, Lordship, to file affidavit.
Yes, that's just come. The second time is come. Yes, MS Merchant, by the prays allowed for the 2 weeks time to file affidavit. Yes.
Highly blessed.
List thereafter. I think there's no need for affidavit only. It's all the same. Similar orders to non-furnishing of ACR, similar to the other matters, correct?
Yes, my Lord.
Hearing.
Yes, but because he's not there. Yes.
Hearing, supplement 8.
What is the order?
Sorry. Here, orders 5.
Lordship, DSGI is still on legs.
Yes, start. What do you have to say? Let him come. Yes, no. What do you want?
There is a development in the case. They have debarred us our farm for 2 years. Can you see this?
The blacklisted.
Blacklisted, my Lord.
Then you have to withdraw these and
no, kindly see, I marked it, my Lord. Kindly see that. Kindly see the
debarment.
Reason. Oh. Kindly see the reason. Kindly see the reason, my Lord.
What see, Mr.
Das.
This is the new cause of action now.
Yes, ma'am. This is major cause of action.
But then you have to challenge it.
Yes,
so while
I will challenge it,
exists, you can't. That means you're out of contention in the tenders.
Ma'am, kindly see the reason. For just a minute, madam.
What can the court do? We can see it.
No,
can we pass orders on something?
No, my Lord. No. Thing is that, my Lord, but the ground who they had taken, my Lord, found to be wrongfully obtained with incorrect means and information by putting them under coercion. This is the reason.
You challenge it, Mr. Das.
This is our challenge, my Lord. But the thing is that, my Lord, let these cases be pending. But this is liable to be a state, my Lord. Lordship, I think. And the next reason is, my Lord, there are 2 reasons, my Lord. Another reason is that in the year 2021, I gave some false document for which I was already punished. But this cannot sustain, my Lord. And moreover, my Lord, my rates are, I am the L1, my Lord. If I am eligible, my Lord, for the financial bill.
No, but Mr. Das, yes.
Let this case be pending, my Lord.
Yes, Mr. Das today has submitted that when the matters are pending for this court, the respondents have issued an order dated 20th August 2025, debarring the petitioner company from
For 2 years, my lord.
For 2 years, on grounds of breach of code of integrity.
But 3.1 and 3.2, my lord.
And we won't worry.
Lordship may also quote it, my lord.
He submits that the debarment is without any basis, and prays that the instant matter be kept pending to allow him to take recourse to appropriate legal remedy.
Lordship may keep it that as a record.
According on the submission of the Contempt petitioner, these matters shall stand over to after 2 weeks.
My lord, after 4 weeks, my lord.
4 weeks. 4 weeks, yes. Leaving with the deputy to petitioner to seek a remedy in accordance with law.
Item number 6 and 7 is also same.
Very unfortunate.
Very unfortunate, my lord. Very unfortunate. My government money, my lord. My rates are low. I am from West Bengal, but they are not allowing me to enter in their system, my lord. God bless you, Lord.
Lordship, this last question, there was some queries from the court that when this ACL has been written in 17 and how it is review has come in 19 and what is the result. So in this session, I just request to this office to have some instruction. So Lordship, they have given the written instruction, this matters, this what is the justification about it. So may I please you?
Mr. Nompur, we'll have it next week. They've given very detailed.
Lordship, I'm saying that endorsement is not even required because it does not fall under 37, Your Lordship. Because 37 requires if the disparity is more than 2 points, Your Lordship. Now the disparity in my...
What have they said here?
That is, they are saying
that... Where have they said from here? Where have they said?
Lordship, here they only explained why it was endorsed after 2 years.
Yes, where have you said that? Why is it endorsed after 2 years?
2.1.2.
Right.
2.1.2, Lordship. In the first page, the second column, Lordship, reply column.
See, because they say that's observed the endorsement of the SRO is necessary as there's a variance in assessment of the IO 7 points and RO 5 points.
5 points.
So is it 2 points? That means 2 points specifically, or it goes beyond 2 points?
38 says more than 2 points, Lordship. More than 2 points.
Is it 2 or more than 2?
Lordship, can you have page 27 of my repetition? The ROI is annexed to
Dr.
the petition.
Mojika, ask him the DSGI. Now, whether endorsement has to go to SRO in an ECR form, IO, RO, SRO, correct? Now, his case is that the SRO who reviewed it downgraded from, first it was the IO who gave 7. Then the reporting officer, or reviewing officer rather, he gave 5. That is found 17. Now, 2019, after 2 years, the SRO, he endorses what the reviewing officer has given by saying that the IO may perhaps was too liberal. Now, the submission is that unless it's over 2 points variance, then it does not need the endorsement of the SRO. While the instructions received is that there's a variance in 2, that's why the endorsement of SRO was necessary. But that's done after 2 years. So is it 2 or greater than 2 or 2? My throat is gone.
I should kindly have page 27 of the repetition. The ROI is annexed therein.
Is it 2 or more than 2? 27?
Page 27 of my writ petition. Rule 37, Lordship.
Yes. Where is difference with more than 2 points?
Lordship.
More than 2 points.
Between outstanding and above average. Is your difference above 2 points between outstanding and above average?
7 and 5, Lordship.
Let's see 7 and 5.
So 7 is
7 is above average, Lordship. Outstanding is 9, Lordship. And above
so
average is
between
7.
9 and 7.
9 and 7.
Not between 5 and 7.
No, they say except, Lordship. Except. When the difference is more than 2 points, except, Lordship.
in exceptional cases where there is a wide disparity in reports, when the difference is more than 2 points, except
First case that this issue has come up is
First time, Lordship.
first time.
The first time.
any authority.
Lordship, I've placed that Meghalaya judgment, Lordship, which says the IO and the RO are of the same. The subsequently under
No different premise. They are same fine.
Lordship.
That you are saying that they can't have two varying kind of grades if they're the same people. It has to be
What has
comparing
happened,
with
Lordship, in the Assam Rifle matters now, they have implemented APAR, Lordship, not ACR. So even in this juncture also, at this time, they should have implemented APAR, Lordship, not ACR, Lordship. That will have some difference.
And 38. 38B. Oh, he's not a junior commission officer. He's a junior commission officer.
He's a Naib Subedar, Lordship.
He's a
He's a
GCO. Then he'll come to 30, he'll come to 38B.
But 37, 38 has to be read together.
CR, the following cases invariably be endorsed by the SRO. B, GCOs whose respect assessment of IU and RO at variance affecting the career. That applies to you then.
But even otherwise, Your Lordship, even otherwise, but
we will look at that otherwise, or
Lordship.
whatever. 2 years is a long period.
Lordship.
But I mean, regarding the whether the endorsement is necessary or not, that's the only thing we're looking at.
But the
you've mentioned it here, 38B, in the explanation. See, you didn't just it is. Excuse me. Is observe the endorsement of the SO necessary as a variance assessment IO and in terms of para 38B. So you are stuck there.
Because B will interpret in their favor, in favor of JCO. JCOs whose respect the assessment of IO and RO each at variance affecting their career.
Yes.
So
it has affected his career in a sense that only in that for that that those 2 years, which years are those?
7 to 5.
Okay.
7 to 5.
Affecting his career.
Effective years that you've been given that 5.
5.
Yes.
But the impugn order is silent even on that aspect. Why I was deducted 2 points, Your Lordship. The impugn order does not specifically mentions that. Why I was downgraded. What was the reason for my downgrading?
See, the category say submitted that the ACR for the year 2016 was reviewed in terms of 38B. Meghalaya also they've answered. No, that's why. Even in the speech, in Annexure 2 of their instructions. You seen all in the enclosures?
Gotcha.
Yes.
But even otherwise, Your Lordship, the SRO has already given the same points as the RO has given, Your Lordship. Now the disparities between IO and the RO, Your Lordship, 7 and 5.
Exactly.
Now in the impugn order, Your Lordship, there's no reason why I was downgraded to 5 points. And even I've shown Your Lordship the previous ACR, Your Lordship, that he was graded 7 points prior to that, Lordship. And this Meghalaya judgment specifically says that, Your Lordship, when the IO and the RO are of the same concerned officer, Your Lordship, prior communication should have been given, Lordship.
See, the thing is that now they have got inconsistency. They have referred to your 10 years ago.
That will amount to violation of principal natural justice, Lordship. Because the relevant promotion criteria is for 5 years, Lordship.
Now it's already been promoted, correct?
Yes, Your Lordship. I'm seeking for
retrospective
promotion.
So, the instruction I received have to go on this only.
Have to go on this only, that's it. Meaning?
Receive this instruction whatsoever received. I cannot.
So as per instructions, where is this case situated now?
So, as per the instruction and then whatsoever citation cited by this petitioner, this based on the office memorandum with the government for the civil employees. There is no SOP as such in Assam level. And there also this, it is a government of India undertaking, and the officers belongs to this. They are the civilian employee of the BSNL. So due to this, these citations was referred, and this logical conclusion of this judgment cannot be taken into consideration in this instance case.
Lordship, the argument urged by respondent is not correct, Lordship. These memorandum are applicable to the Assam Rifle personals. Lordship, there's I'll just place this judgment, Lordship. Your Lordship is also part of the bench, Lordship. This is Afan Faruqi, Lordship. Lordship, page 7, internal page 7, Lordship. Para 13. The division bench has also referred to the same notification, Lordship. May 14, 2009. Paragraph 13.
Para 13?
Para 13, Lordship.
Please check it out.
In the Faruqi case, this was commission officer.
DOPT.
Lordship. 14, 2009, Lordship. And in the Meghalaya judgment also is the same notification, Lordship. 14, 2009.
You see it's not applicable.
And Lordship, in this case,
in his case, this is the commission officer. It is not this is the commission
officer.
Yes.
In this case of Muhammad Afan Faruqi.
Yes.
Lordship, the Honorable Division Bench, while passing the order, has
there is lots of difference here. This commission
that
non-commission.
Since the rules are invoked and the notifications are invoked, the entries should have been communicated to the concerned officer, Lordship.
What is the point here in this case?
Lordship,
Yes,
this is
he
the
was not
case where
given-
the ACR was not communicated to the concerned officer.
Yes, yes, I remember. Only that it was, yes, that he had been given due notice.
Lordship.
Yeah.
And that he had signed in the ACR whereby the respondent says that he has already been informed about his greetings, Lordship, adverse entries. In
Yes.
this judgment, the court has granted the respondents to grant a retrospective promotion.
Directed for
even in this
promotion,
matter.
yes. I remember that. So your matter only that how Mr. Debnath are you to come to with impugn order? 157. You just have to justify 157 para C. Bottom. Yes.
So this has been
justified. If you can justify this, then he has no case.
So you listen.
That's the only thing now.
So this one is with in parasi. This is given on period the inconstitutional reports of the petitioner from the assessment year 2001-2022. It is revealed that he has been graded average 2 points in the annual constitutional reports considered for the assessment year 2007-2008, increase the ranks of the general duty, and high average 5 points in the rank of the eligible Subedar general duty. In the annual constitutional reports for the assessment year 2014-15 and in 16-17 are grading awarded in annual constitutional report by eligible officers and reviewing officers are purely based on the performance of eligibility during the assessment period. Hence, the award of 2 consecutive average 2 points grading in the rank of Havildar general duty and high average 5 points graded twice in the rank of the Naib Subedar general duty have been taken into account, which clearly reflect the poor performance of the petitioner. So,
so now one thing is that just to help you, if you place reliance on this grading, correct, made in 2006, 2007, where he got only 2. Now, at a point of time, was he afforded the opportunity to represent against his low grade? So because if you want to place reliance on something, that must be, it must be, what do you call it? A fact that has already been established and, has also to his knowledge and notice, to which he believed reasonable opportunity to represent against. Because now your reason for not considering to upgrade his ACR is not because of the relevant year or the difference in 2 points between the RO and the IO and the RO, correct? Although for the 5 years, which is in consideration, he has averaged 7. And only in that 16-17, he has, that is 5.
5.
So that's the thing. So now, are you considering, now his prayer was that, okay, fine, I was not communicated, represented. Your consideration is whether he deserves to be graded 7. Number 1, the IO and RO are the same officers who gave him 7 earlier. Number 2 is consistent for 16-17. Apart from that one, apart from 16-17 for the 5, applicable years, he was given 7. Now, in this speaking order, you have reverted to the grading given in 2006-2007. That's the only thing. If I understand correctly.
So this, this
only this aspect, you can clarify that yes, we were well within our powers to make this, wider assessment in the consideration of upgradation of his ECR. Then well and good, he has no case.
So, second first questions of this court, this was the instruction I received. This is given only the communication took place when ACR is written.
No, we're not there. The thing is that speaking order has been passed. Speaking order says we are not in, they're not inclined, we're not inclined to upgrade because of his performance in 2006-07. So it's not a case of where he's consistent, he's been consistent performing at 7 and suddenly it came to 5 with no reasons being given. That's the only thing.
So in such situation, if this order is could find that this reason is not given, and then it can be given the consider this as per the matters and then pass him.
No, that's as per. I think that's the only thing. Is below benchmark the four, but so you see below benchmark for 2007, 2008, 2014, 15. 14, 15 also.
No, Lordship. 15 I was graded 7 points.
Then why is it written here, para 7, last line?
Elusive, this matter has come up due to this page 137.
14, 15?
Why it is come up 14, 15 also elusive? This page 137.
Yes.
So elusive paragraph 7. It is further provided that
earlier track record will mean the 5 proceeding, the 5 years which are to take consideration for consideration of promotion.
So elusive here it is the matters why that we can even
so you mean to say that this court said that the should take account precious early track record. You go back to 20 years ago.
So this may be the reason elusive point.
Is it permissible?
Earlier track records.
Page 107 is the required benchmark for promotion in my case. It specifically says 5 relevant years, Lordship.
That is one. Where is that?
Page 107, Your Lordship. Can you see on the top for DPC 2 2021 and onwards? I'll fall under category B, Lordship. Naib Subidar to Subidar. All 5 ACR, that is from the year 2016 to 2020. So this is the relevant 5 years that they should. The ACR should be taken to.
So what are we to do, Mr. Debran? This aspect earlier we also asked to examine whether it's permissible or not.
Now, even for that 5 points also I was never communicated with any warning or any sort of any communication letter.
We'll dispose it off. No more submissions to make.
So elusive this as per the records first I got the instruction. So more than this instruction I think will not be. And another aspect of matters, if this communication, whether any communication there in between and others, then I have to take further instruction.
You have to?
I have to take the further instruction in the matters of this if there are any communication and when this correspondence took place, when review is given and taken 2 years.
You have authority to show that beyond the relevant years for consideration that the authorities can look preceding years also for a question of upgrading the ACR, or it's limited to 5 years. That's the only question this court has. If there is something that allows you, then
listen, as regard the paragraph C, if you come to the paragraph C and taken this earlier period, so this first offer is I should make submission on the matters that's in page 137 when this court has passed the order, Your Lordship. So based on this order, when they are going to consider this ACR, then they have taken the past record as a whole. So it is not that intentional that a department went beyond 5 years to find out some loopholes. This is not the correct position because
we're not saying finding some loopholes. We're saying whether you have the power to review beyond the relevant assessment period. That's all.
So as per SOP, beyond 5
Meanwhile,
years.
judgment says what? It's 5 years.
5 years.
So in this judgment, first we are given 5 years, and then in this this SOP also has continued to 5 years. So we are not contributing matter. This is position is law, and then.
So the only thing is that now you're then limited to that. It's not a proper speaking order.
So here, Your Lordship, the citation is given, and in this citation, so as given the office memorandum. This office memorandum, my submission is there, Your Lordship, that it is pertaining to the in the even judgment it is given. It is for the civilian employee of the central government.
Yes, so we're not looking at that also. What's the judgment, Bhagwan?
Judgment paragraph 21. Sub paragraph 2.
You get a copy. Oh yes.
Paragraph 21, you will see this office memorandum, and after that, next page you will see page 5, paragraph 2. Keeping in view of the above position, the matters regarding the communications of entries in the ACR in the case of civil service under the Government of India has been further reviewed.
Where are you reading from?
This page 5, paragraph 2, in subparagraph 2 of 21. And in this memorandum, we will see another aspect of subparagraph 2 in Roman 4. In this same paragraph, you will see Roman 4. The concerned officers shall be given the opportunity to make any representation against the entries, and the final grading given report within period of 15 days from the date of the entries in the ACR. So here in this central government and civilian employee is given. When this DPC is held, and that time they are going to proceed to DPC held, and then if find any shortcoming, and it will given the opportunity to be heard, and then it will be within 15 days they have to give. So prior to submission this. So,
how are you concerned with this one in this case?
So
we're not concerned with it.
We're not concerned because our SCP is completely different.
This is APR. Whether we send it back or...
Lordship, I have submission,
So,
Lordship.
Your Worship, in our,
We send it back.
in our
So
SOP,
when I approached this honorable court, Lordship,
Yes.
in the first round, this honorable court has directed the respondents to communicate the adverse entries and allow me to submit a representation. Now the representation is confined only to the adverse entry made against me in the following year, that's 16 and 17, and so the representation is only confined to that, Lordship,
No, we
not to the
understand
relevant
that. We
years.
understand. Should we remand it back for reconsideration or... Because
Lordship, Lordship, I'm relying on this McWell judgment. The ACR itself is invalid in the eyes of law, Lordship. Now another submission.
When you see, it went to a tribunal first. It was adjudicated.
Lordship.
Then a tribunal has found that to be illegal. That is why what the Supreme Court has done is just endorse the final tribunal. So the
Lordship.
thing is that it's not a question of, that
No, the judgment says that the IO and the RO is of the same officer, Lordship, for two relevant years.
Fine.
Now whether
Just come with that paragraph I noted earlier. So it is no interference the court's call for, yes. That paragraph, you mean you want to go to paragraph 21?
yes, Your Worship.
Where you said that's the same person?
Lordship, para 3, Lordship, para 3 of the judgment, it says the IO and the RO are of the same for the 2 relevant years, Lordship. Para 3 is the facts. Both were the same officers.
Where is his same?
Lordship, para 3.
Okay, yes.
Lordship.
No, the finding that because this is...
Because that remark good was not communicated to him, Lordship.
No, where's the finding with regard to the same IO and RO that has vitiated the second assessment? Where is that?
Lordship, para 26. Para 26.
Where is that? Where is that but same persons? Where is that?
Para 25, Lordship, sorry. Para 25. There's a finding by the tribunal, Lordship. Para 25.
That's a tribunal finding. I'm saying about the Supreme Court.
The Supreme Court has accepted the finding of the tribunal, Lordship.
That's what this court was saying.
Not true.
It's relied only on tribunal. It said no interference is called for. Because when this against the tribunal's finding, I think the Union of India filed a writ petition. Then this matter was filed again before the Supreme Court.
Lordship, the matter was filed by Union, Lordship.
Union, that's
Lordship.
what.
Now the judgment is that the respondent the ACR was expunged and it was directed to pass necessary orders, Lordship. So the judgment, the order passed by the tribunal was not interfered.
See, this is on a different premise because they have taken consideration years which are not within the relevant years. That's your case. It's
Lordship.
A bit different, this one.
No, but the IO, Lordship, the principal, Lordship, the IO and the RO is of the same person for 2 years, Your Lordship. And I've shown Your Lordship the relevant ACR.
That it might be the same person, but they relied on 2006, 2007, where you got two. That's what they've done.
In this case, the 11 years will be 2006, 2007, 2008.
No.
In this case, McWell case, Lordship.
No. I'm talking about your case.
In my case,
the non-upgrading is because of the earlier track record, not because of what the same IO or RO, nothing of the sort.
But the representation in which they have rejected
please try to understand the court.
Lordship.
The speaking order has said that you are graded average 2 points, 7 and 8, the rank of Havaldar, general duty, and so. That's why. So that is why you have not been given you're not considered fit for upgradation. Nothing about CMIO, RO, or that your relevant years have been considered. Nothing.
They're silent on that. That's why I'm saying.
That's what I'm saying. Whether we send it back on that point, it's not a question of your grading being done relevant years and they refusing it in spite of the INRO being the same. That's where your case is different from Meghalaya.
My submission will be the relevant consideration 5 years for promotion.
Take down then. Better. The writ petitioner being aggrieved with a speaking order dated this is 30th November, right?
30th November 2023.
Passed by the respondents in pursuance to a judgment order of this court dated 24th August 2023 in WPC number 203/2022 is before this court. Assailing the same on the following grounds. First, that though the representation of the writ petitioner was confined only to the relevant year of 2016-17, the respondents in refusing to upgrade the ACR had referred to the years 2006-2007, which are not to be taken into consideration. The second ground for a challenge, the second ground taken is that the initiating officer (IO) and the reviewing officer RO were the same persons who in the earlier assessment of 2015-16 and subsequent also 17-18.
16-17.
And 16-17 were the same, and that a downgrading was without any explanation or reason. The case of the petitioners that the non-consideration for upgrading not being based on any cogent reasons or circumstances, the petitioner has been deprived of the promotion at the relevant point of time. Next paragraph. Mr. Embal Nompur, Senate Counsel for the petitioner, has submitted that due to the non-furnishing of or non-communication of the adverse entries or grading point for the year 2016-17 had filed a writ petition before this court, being PC number 293 of 2024, wherein he submits which was disposed of by order dated 24/8/2023. The Learned Counsel submits that as per the order dated 24/8/2023, the respondents had communicated the adverse entries in the ACR of 2016-17, and the petitioner, on receipt of the same, had submitted a representation praying for upgradation of the uncommunicated ACR with a further prayer for retrospective promotion with effect from 2/11/2021, as also for restoration of seniority. Learned Counsel submits that, however, the respondents, by the impugned speaking order dated 30/2023, have not considered the prayer and have rejected the same on the ground that the writ petitioner had been graded average within bracket 2 points in the ACRs successively for the assessment years 2007 and 2008, while in the rank of Havaldar bracket general duty. That counsel has vehemently argued that what has been resorted to by the respondents is impermissible in view of the fact that the requirement for consideration is limited to, in the case of petitioner, is limited to 5 assessment periods. That is from 2016 to 2020. Stop. He therefore, any other submission? Apart from that, that's the core
is
submission.
in substance, Lordship.
Yes,
But
sir.
Lordship, that the ACR has become invalid because of the endorsement by the SRO after 2 years.
Oh yes, of course. Sorry. Further submission is made that the ACR of the writ petitioner had been endorsed, or he submits that though the ACR of the writ petitioner had been completed by the initiating officer and by the reviewing officer in the year 2017, the endorsement by the senior, what we call senior receiving officer,
Senior reviewing officer.
receiving officer, was done only in the year 2019 after a space of 2 years stop. He therefore submits that the assessment not being made on any rational basis the same is liable to be interfered with. In support of his submissions, the learned counsel has placed reliance on the case of Union of India and others versus G stop R stop Meghwal MEGHWAL, reported in 2022 SEC online SC1291. Next paragraph. Mr. R. Devnath, the CGC, in reply has submitted that as per the directions of this court, the respondents had, on receipt of the representation from the petitioner, had considered and passed the impugn order. The learned counsel has placed heavy reliance on the direction of this court with regard to taking into account the earlier track record to justify the non-acquisition of the grade of the petitioner on the basis of his earlier performance in the year 2006 or 7 or 7 and 9. It's 6 and 7.
Seven, 8.
7 and 8. He submits that as in these 2 years the performance of the writ petitioner was below the prescribed benchmark, the respondents did not consider it fit to upgrade the ACR, and as such what do you say?
Your Worship, that's the
reason. First he said that because early track record would mean, no limit, correct? And then?
So, Your Worship, here, as per our SOP.
No. What are your submissions?
So, I'll just refer this paragraph 13, paragraph 13 of my affidavit, 13, 24 and 25.
That means you mean to say that an ACR once finalized cannot be reviewed?
Yes, sir.
Is that your contention?
So this is my affidavit, Your Worship. This is in affidavit, Your Worship. Right. 13 is given. And then SOP also given. And there is a record of instruction also there.
Yes.
So department to follow this ROI, which is applicable in this case. And moreover, there's
one second. Yes, RAI 4. 2. Tom, no. Let's stop. The learned counsel has then referred to the affidavit and submits that there is no provision that exists in the record office instructions, bracket ROI. For review of an SCR once finalized, which, but however, the case of the petitioner was taken up for consideration. Do you mean to say, see, it's not a question, it's under court orders. What you're talking about is ROI 4 of 2002 refers to only that once an assessment has been done, before he has come to court, when it's still promotion, then there's no alteration, even when it comes for promotion. But he has come to court and the court has ordered that you review it. This ROI will have no force.
That's why Lordship in all those matters had disposed of the petition directing them to pass a...
They have no force. The submissions has no force. Only the question of this ROI, I've not read it, 4 of 2002, will apply only in cases where there's no interference from any other quarter. That's only that they don't, it says that once an assessment has been made, it doesn't allow the officers again to upgrade it unless it goes to headquarters on certain considerations. Where's that ROI? Page? R4. Yes. Where is it? Where is it? Where? There is it. Read the relevant part, page 33 of your affidavit. Where is it from? Where? Show me that, man. Where is it? We will note that because you have submitted it. Where is it? You just go from page 33 onwards. Where is it?
This one is yours.
If you're submitting a point, you should place the material.
This is the Department Promotion Committee in DPC, you see.
Which page?
Page 34, you see.
What does it say?
Let us come to page 33, you see. That's it will be promotion cadres. All over will be put through 2 promotions and cadres prior.
Where? That there can be no once is finalized. Okay, forget it. No. No, it was finalized. Stop. Stop. What's the further submission? Forget this ROI now, that's over. What's the next submission? I want to record submissions. What's the next submission? No, don't look at the affidavit, Mr. What's some? But I've not made any notes also, so I don't know. Okay, sure. What's the next submission?
So, next submission of mine, you'll see there's the order passed by this.
Exactly. Come to the speaking order. How do you defend it?
So, this is the speaking order because of
no, why? How do you defend it? Why do you say it's perfectly above board and there's nothing wrong with it? What are your points? Okay, just note them.
So, my points is here. You'll see that's when this taken into consideration 7C. And paragraph even 7, that's it. They have taken into consideration of the past record and including the record of 2014-15. And
14-15, where does it come in? That is what also.
So this
yes,
the performance of the petitioner was taken into consideration for the 15-16, 16-17. So when the performance is taken into consideration and there is no adverse remarks for which it was required to be communicated, there is no adverse remarks against the petitioner.
What do you say about the same officers?
The officers will remain same.
You make it you see, at least when you make your reply arguments, just put it in a coherent manner that we can also the court, you assess the court so we can note them down, you see. You understand?
Yes.
Yes. So we can complete this matter.
So it is paragraph 25, this bottom, this one you can count. Regarding the communication you have received.
Which page a chart given in your regarding this
page 20,
in your petition?
Page 20. Page 20.
The chart for the
73, Lordship.
Page 23. See, 14-15 is outside the purview of this. It's only 15 to 20, correct?
16 to 20, Lordship.
15, 16 to 20, 21.
But this 1, 2, 3, 4, 5, 6. Here there are 6 years, Lordship.
No, in
the relevant 5 years is for 5 years from 16 to 20, Lordship.
Okay, yes. Mr. Dena, please, what's your submission?
So here,
now you said that if taken 14-15, how do you justify that?
You receive 15-16 is recommended, so alright, you receive this.
No, not all right. You said that come back to the impugn order. We only want to hear submissions on why there's nothing wrong with impugn order and why there should be no interference. That's all.
So here you receive this points is given based on the performance of the petitioner, and this is not the adverse remarks according to me, you receive. This is not the adverse remarks for which it will be required to be communicated to him.
See, now the laws change now. In any remark, suppose you're outstanding, then next remark given a high average, that's not adverse entry, but it has, your performance has dipped. So that should be communicated to you, that judgment is there. Any entry has been communicated now. Suppose you're a high performing officer. You have outstanding, so suddenly you dip to very good. Then what happens? It's not an adverse entry, very good. But it will be considered an adverse entry in relation to that officer because he's an outstanding officer. The whole concept of adverse entries changed. Before, adverse entries that he's incompetent, he cannot do this, he cannot do that, doesn't obey orders. Those are real adverse entries, right? Negative ones. So these new adverse entries, which are considered adverse, is like suppose, repeating again, that suppose performance is A, suddenly in one he gets B. B doesn't mean that it's bad or below average or average. Means very high average but below outstanding. Then will that be an adverse entry to him? It will be.
Yes. Definitely not be adverse.
Then your submission will have no ground. You say that they are not adverse entries. Entries will take it, entries. So first submission is in support of the impugn order.
So you will see, even though if you consider this it is not the speaking order, so then it will be incumbent on the part you will see that in such.
It will be incumbent upon
my part to make the submission. You will see that's then we can refer the matters to have this give the speaking order, considering all aspects.
No, I want to record your submissions. We don't report. I don't report your concession. What is submissions?
Because
your submission number one is that earlier track has been taken. Why it's been taken? Just justify the statement.
Earlier tract is been taken due to this order of this honorable court, based on which.
Okay, fine. Order of this court.
Order of this honorable court.
That's it.
Based on which this earlier tract has been taken.
Yes, the impugn order he submits.
Passed in WPC number 293 of 2002.
Submits being in pursuance to and as per the orders of this court.
Passed in WPC number 293.
Has addressed the issue and has also taken account the past track record of the petitioner for the assessment years 2007-2008, which has thus prevented any upgradation. Therefore submits there being no infirmity with the impugn order, no interference is called for by this court. So that's it. Very good. Having heard the counsels for the parties and also having examined the materials on record, it is noted that the issue in question after the speaking order had been passed by the respondents is whether there is any justification in the respondents taking into consideration the performance of the petitioner beyond the years which have to be considered, beyond assessment years considered for the purposes of promotion. Stopped. In the instant case, it is seen that the promotion in consideration is from Naib Subedar to Subedar, and as per the benchmark for performance appraisal for promotion and financial upgradation under MACPS dated 29th December 2016. The same requires all 5 ACRs from the years 2016 to 2020, which should be not below very good, I would single inverted commas, and after that bracket above average, which is not really very good, after bracket above average, then after the bracket 7 points. So the further prescription is that the same should be the benchmark in all 5 reports. Correct? Yes. Where's the ECR?
ECR will be at page 82, Lord.
80?
82.
Stop. A perusal of 82. A perusal of the ECR for the relevant year, that is relevant year गर्म पानी दो. A perusal of the ECR, that is for the year, the assessment year in question, that is 16-17. Page
82.
Reflects that the petitioner had been graded as 7 by the initiating officer, with the remarks that I will in single commas, individual is physically fit and robust. Stop. He enjoys good command and control over his subordinates and is dependable. Close quotes. The same was endorsed on, or was made on 2011-2017. The reviewing officer thereafter had graded the petitioner at 5 with the remarks without any negative remarks except without any negative remarks, and had recorded with single commas a physically fit JCO who executes assigned tasks with dedication. Stop. The ACR of the petitioner is seen is then endorsed by the senior reviewing officer. Before that, and executes assigned tasks with dedication. Stop. The same was done on 30/12/2017. Stop. Then after that, no. After that, SRO. After all, then the SRO was endorsed. After that, after 17 more. The ACR of the petitioner was then endorsed by the senior reviewing officer, SRO, after nearly 2 years on 27/8/2019 with the remark within single commas, a high average JCO. Stop. I agree with the assessment of the RO. Stop. The IO is liberal in his assessment. It is thus seen that the petitioner from the grade 7, from obtaining from being granted 7 have been downgraded, and the same was endorsed by the SRO. Stop. It's also to be noted that no reasons have been afforded or discussed in the report, or no remarks have been noted in the report as to the downgrading of the grades. So further, an interesting point to note in the present case is that the initiating officer and the reviewing officer were the same officers for the preceding assessment year, that is 2015-2016, who had graded the writ petitioner at 7 and recommended him for promotion. So, next paragraph. In this backdrop, this court is now to examine the speaking order passed by the respondents as to whether the same, as whether the same had taken into consideration all the relevant factors. First is the fact that apart from the assessment year 16 and 17, the petitioner for the years 2015-16 and from 2017 onwards till 2021 had been given a grading of 7, or in other words, recommended for promotion. And in fact, it is only assessment that was done in the year 2016-17 that has prevented him from being considered for promotion at the relevant time. And that is 2021. Correct? Yes, 2021. So, the order, the impugn order, has observed, the impugn order, it appears, has been passed solely, having order refusing the upgradation to the petitioner, it appears has been passed solely on the ground that the petitioner had been graded average bracket 2 points in the ECRs successively for the assessment year 2007 and in 2008 while in the rank of Welda General Duty. Stop. Further, at para 7 of the impugn order thereof, though the benchmark clearly prescribes the relevant years to be from 2016 to 2020, it has been recorded that the performance of the petitioner during 2014-15 is also below the benchmark. So, next paragraph, on same paragraph. Though the learned CGC has tried to take shelter of the orders of this court, which has been, which paragraph is that?
Para 7 of that.
Which page? For the petition? This order from this court, whereby you?
That will be at page 137. By
referring to paragraph 7 of the order dated 24/8/2023, passed in WC number 293 of 2022, wherein it is observed that in the consideration for upgradation of on the representation of petitioner, this is para 7, wherein it is given as follows. Which for the sake of convenience is reproduced and below. A perusal of the same, however, will show that the directions are for consideration of the representation of the writ petitioner, taking into account the petitioner's earlier track record. Stop. This would necessarily therefore mean that the benchmark as prescribed by the what reform by the
107
by the reform benchmark performance appraisal
105
103
105.
yes. So, does necessarily mean that the respondents were to consider the representation in accordance with the benchmark as given in the memorandum dated 29 December 2016 bracket Naksha 10 writ petition, and not refer to years, assessment years, which were not to be taken into consideration. Further, it is not understood as to how the assessment year 2014-15 has also found place in the impugned order. Stop. The other aspect which has also been raised by the writ petitioner with regard to the same initiating officer, reviewing officer for the 2 years giving grades in variance, it appears has also not been taken, has also not been taken into consideration by the respondents while considering the upgradation of the petitioner. Next paragraph. In these circumstances, therefore, without dwelling any further to the merits of the case, it is seen that the speaking order passed dated so-and-so, dated 30th November 2023, has not addressed the points, has not addressed the representation of the petitioner in its totality, and as such is is set aside with the direction that the respondents, as per the observations made in the judgment, reconsider the representation of the petitioner against the benchmarks prescribed for promotion for the to the set post for the relevant years of assessment. Correct, sir. It's expected that the said exercise will be complete within a period of
4 weeks.
4 weeks, very short. Within
Like
6
weeks.
8 weeks, yes, from the day of receipt of this order. Yes. By the that should make it straight.
Lordship. Lordship.
Yes.
Highly obliged.
Item number 12.
Yes, MS Ibla.
Miss, may it please your lordship. Your lordship, I filed an application with regard to the.
Lordship, I have an objection to the application filed by
Why?
them. Lordship, the application is marked by serious defects, Lordship. If I may, Lordship. Firstly, Lordship, there are only 3 paragraphs in the said application, Lordship. If Lordship can turn to page 8 of
Only
the
3 paragraphs?
Lordship. Lordship, how it has been verified, Lordship, if Lordship comes to page 8, Lordship.
That is of the main case, the verification.
The verification, Lordship, it's shown that there are 33, 34, 35, 36, 37 paragraphs which has been identified as knowledge, belief and information. And
who drafted this application?
I drafted, Your Lordship. I drafted.
See, to make amendment application,
Yes, Your Lordship.
what amendments you seek to make the petition, you should write it very categorically
Yes,
in
Your
the
Lordship.
application. Suppose you want to make an amendment to a certain paragraph,
Yes, Your
or between certain paragraphs.
So, Your Lordship, this is not an amendment application, Your Lordship.
This is what?
This is praying for allowing us to amend the the instant writ petition.
No.
Yes, Your Lordship.
Even when you a prayer to amend,
Yes, Your
you have to, if we allow it, then you're allowed to make amendments, correct?
Yes, Your
now you're saying just a blanket amendment you want to make.
Yes, Your Lordship.
We have to know what amendments you want to insert into the petition, because a writ petition is like a, it's based on pleadings only, correct?
Yes, Your Lordship.
So suppose MS Ibla wants to make what amendments to paragraph, after paragraph 35 you want to insert
Yes, Your
35A. Now what do you write there? In the amendment you have to write,
Yes,
just
Your
like a law class I'm
Yes,
giving
Your
you. After para 35, this para 35A reading as such, we pray it be allowed to be amended to that extent. So you write the amendments at extent after 35, 35A, 35B, after sentence so and so. Those you should put in the application.
Yes,
then the other side has been given a chance to see whether those pleadings are in consonance with the main petition or whether they make up an entire different case.
Yes, Your Lordship.
That is why amendment you have to incorporate all those amendments which you're seeking to make.
Your Lordship, actually, Your Lordship, on the last occasion, you told us firstly to file an application.
Exactly. Once you file
Not an
application, you
amendment
have to
application,
show
but-
what amendments you want to make.
Yes, Your
And then after we allow it, then you file amended petition incorporating the amendments which you have sought to make. You file a fresh one.
Yes, Your Lordship.
One more thing is this annexure is, which the annexure mentioned here, only date is mentioned, it is not annexed.
No matter, yes, Ms. Ibla prays we have to withdraw the incident miscase. Will be to file a fresh one, incorporating that amendment. It seems allowed, yes. Give for 2 weeks.
1 week, Your Lordship.
15.
1 week.
Yes, sir.
Yes.
Please, Your Lordship. Lordship, due to some emergency, the DSGI had to leave the court premises. Therefore, I'm praying, Lordship, if Your Lordship would kindly take it next week.
What happened in emergency?
As his presence is important, Lordship, in this matter.
After 2 weeks.
Lordship, only thing is that we have filed the report in pursuance to the order dated 4th.
After 1 week, Mr. Dev.
Highly obliged.
Obliged, Your Lordship.